Well, I'm pleased to welcome you here today to look at best practice construction contracts, to look at contracts from a more global perspective and get an overall strategy as to how to attack your construction contracts. So we'll cover a lot of topics today, mainly in general. The detailed grammar of the contracts is always a challenge, but that's for another day. We want to get an overall strategy that allows us to get the best contract for our projects. So you've got to look at what your strategy is, and basically fair contracts distribute risk by the contractual provisions on the law in an effective and efficient manner. And it promotes a competitive market in the short and long term.
Penalty notices remain in place.
And the situation is that it's important when you're in a competitive market that you look at your short and long-term effect on that market and its effect on you. If you, as a contractor, rip off every subcontractor, you're not going to have too many work for you over a period. If, on the other hand, you're reasonably fair but tough, then you can develop a stable of contractors that produce good results for you on a number of projects. The other aspect is that having fair contracts and managing them properly means your projects go better. Not only do you make money on this project, but you get more projects from owners who appreciate a successful comparison. So if you're looking at a project, you're looking at technical aspects, you're looking at contracts, you're looking at financial aspects, and it's bringing all those together in a plan and implementing it properly and then monitoring as you go, that might end up in success. It's important to have an overall objective of it because too many people get drowned in the detail and lose their perspective of getting the project as a whole finished successfully. So in terms of trying to make that happen, you've got to look at the contract drafting choices. You have various styles of contracts. We'll look at the AS 4000 family today particularly, but you've got the MBA, you've got the HIA, you've got the ABIC, you've got lots of varieties to choose from. You've got to look at the administration behaviour on site. If you're going to run a very tightly documented program and you want subcontractors and consultants and others to keep administration up to the nines, then you're better off to start at the start and educate and train people to comply with it so it goes smoothly and doesn't cause hassle later on. The other aspect is you've got amendment schedules that override base contracts, and you have a look at those to make sure that everyone's aware of the particular clauses you want to add to the standard. So if you've got a particular risk, then the situation is you should identify it in your amendments so that everybody is clear on what's expected and everybody watches that risk. The other aspect is you've got to look these days at the social contract atmosphere pervading society. Fundamentally, people these days seem to think that we have to have a social contract in order to earn our profit, in order to carry out our trade. And you've got to look to things a little bit more wider than just the contract and just the construction. So you've got to look to your public profile, the way you interact with councils, with the public, with the newspapers if they are interested in it, the way you conduct safety and environmental issues is all important to getting a sensible outcome to your project. Case study is fracking in New South Wales and Queensland, where basically everybody jumped in, thought it was a good idea, rushed ahead with it, but then the political pushback was such that it quickly sort of died down to a low roar. So the idea was that if it had been introduced more carefully, and if it had been more carefully justified and more carefully sold, particularly to rural communities, it might have had more success. The other aspect you've got to look at in construction contracts is the role of the superintendent. It's historically been very important, and the superintendent sort of acted as an independent expert who decided matters of concern between the parties. He was accepted as somebody who was technically qualified. He was often the person that had carried out the design, so he would know the detail, not only of what was in the design, but also what the client expected. He was therefore able to deal with matters quickly, and if there needed to be a variation to sort a problem, he was in a position to do it. However, these days, there's been more intrusion into his role, more attempts to more clearly structure his role, which was a bit of a conflict between his role as a certifier of the value or the duration of a delay and an agency role where he is actually giving instructions on behalf of the principal. So that's still a developing area in construction contracts, and it's one you should look at very quickly when you pick up a contract to see, well, what's the role of the superintendent? And it can vary from being someone who's got to be fair and reasonable and come to fair and reasonable values for variations and other things, or it can be someone who is not required to be fair and reasonable at all, expressly, and he's only an agent of the principal. So it's important to see that situation from the start. So you've got the idea that he's an agent or certifier, and he's basically both. And the powers under the contract you've got to look at to see what he can do. Because if he's totally an agent and he can order all sorts of things on behalf of the principal, it's a very significant effect on the contract, because effectively the contract is agreed, therefore, that the superintendent can order what he likes through that superintendent who's unrestrained. So you've got to look at his duties and his discretion, and things like suspension, where he has a blank power to suspend whenever he wants, and the contract only gets paid X. The situation is it's a risk. That risk isn't able to be completely removed on every project, but you must be aware of it before you go into it, because it alters your relationship with the superintendent throughout and your relationship with the principal. The other aspect is there was a case where in Doyle Peninsula Abbey Group, where under a standard AS contract, the superintendent was expected to take the position of both parties into account before he issued an extension of time where it hadn't been applied for properly, but the superintendent was well aware of the justification for the extension. In that case, the superintendent didn't order the extension of time, and when taken to court, the court said, no, if you've got to take the interests of both parties into account, and you know the situation behind the delay, and you have got a power to extend time, then the sensible thing is for you to extend it. Since that case, a lot of contracts have excluded the responsibility to consider both parties. And again, you've got to look at it to make sure that you're aware of what role the superintendent will play and how he will look at things that might be of concern to you. The other aspect is you've got the role of the superintendent's reps, and you should look to see whether or not the rep is discharging the duties of the superintendent, or is he certifying the value of variations? Is he giving directions that mean that money will flow? Is he awarding delay claims or not? Or is he simply discharging the agency role, which is to give instructions, perhaps to indicate some minor approvals, but fundamentally he's really only acting for the principal in terms of superintending the job in the way of the old clerk of works. So it's important again to look at the role of the superintendent, and because you might see more of them than the superintendent, and work out what is his roles, what has he got to take into account, and what's his likely actions in times of trouble. So that's it. Standing back a bit, we look at the contract and its interaction with something that is or isn't or is close to a dispute review board. The dispute review board set up in big contracts because they cost some money, and they maintain a day-to-day sort of overview of the contract, but they're not involved in the day-to-day management. So they're perhaps 3 experienced engineers on a major dam project, and they come in every month to review progress and see what the problems and challenges are. They perform a very valuable role, but in lots of more smaller cases, the superintendent, if he does his job, will achieve many of the dispute review board aims. Now, if there is a dispute, the dispute review board can hold a hearing, take submissions, if necessary, they could probably sort of ask some questions of witnesses, although it's not a formal trial. At the end of that, the dispute review board would bring down a decision on whether or not the issue in question had been resolved. So it might be the value of a variation. It might be the effect of a factor on the delay claim, or it might simply be a matter of whether or not a particular work method was used. They are expensive, but they do provide a substantial amount of technical expertise to a project where you get 3 experienced engineers to contribute their thoughts. The other aspect that's got to be looked at when we talk of contracts is time bars. Time bars are a bane for a contractor because, on the one hand, they to some extent are a necessary evil. I was looking at GC 21 recently, and they had a very liberal time bar, and it was only at the absolute final step that contract said that a time bar applied. As a penalty for late notification, they said, well, you won't get interest on your claims. So the way that worked was, if your claim should have been in within 7 days, and it wasn't, but it was within a year and 7 days, well, then you'd lose your interest on your claim. That didn't seem to me to be sufficient penalty to motivate a contractor to apply promptly, detail it promptly, and get his act together promptly. And it seemed to present some problems for the superintendent trying to manage his budget when there wasn't very much of a penalty for the contractor not to supply it. On the other hand, there are many cases where the courts have insisted that time bars apply, and they've insisted that the whole claim is barred if it's outside the time that's prescribed under the contract. And that is a very harsh penalty, because you can have $1 million claim that's technically 2 weeks late, and the courts say, well, bad luck. I don't think it's a correct balance, but it is a balance that contractors should be aware of, and people drawing contracts should be aware of, because the situation is, if you think of a contract where it is usual to get monthly claims, then why wouldn't your normal notification period be linked to that monthly claim? So you get from the contractor a proper report, as long as he's invoiced, and that would detail what claims he had. It may be that putting them an obligation on to nominate early would be reasonable, subject to some sort of partial discount if he was late. But the circumstance is the courts have attributed a great deal of importance to time bars. The rationale they've used in lots of cases is that unless you notify promptly, it denies the principal the opportunity to restructure the situation and save himself the claim. But that's a thin excuse to somebody who's lost a substantial claim merely on a lateness of time bars. Additionally, time bars set up a culture on the contract. And the circumstance is that if there are harsh time bars, people tend to get more litigious and tend to seek extra contractual remedies for any losses. The other aspect you've got to deal with then as now is what's an efficient platform for building contracts. Some people build their own contracts and draft them all from scratch and borrow from one contract or another, but in essence have a customised, fully customised contract. It's possible, it's certainly an acceptable way to approach it, but it tends to get a little bit concerning to those who have to read those contracts and then try and estimate the contractual risk associated. If you have a contract which is AS 4000, most people get used to the balance of clauses within that contract, and they therefore can put some portion, some percentage on the risk associated with contracts. How many claims will be refused, how many claims will be this, what sort of ambit is there in delay claims, etc., etc. So if you have a customised contract, it tends to make everybody that more careful about the risk involved in it. The other aspect is that they do get outdated quickly. The situation is that AS 4000s come out in 2025, but before that, the last sort of update was in last century. So they do get outdated, and you've got to provide usually a schedule of amendments that improve the contracts. There is a practice that the Standards Association encourages, which allows people to insert amendments into their standard contracts without definition of them, without making that prominent. I don't think that's a really acceptable practice, and I think it's to be avoided where possible. It seems simpler to me that if you've got amendments to be made to a standard contract, you attach a set of amendments so that listed from 1 to 25 is various amendments you've made or extra clauses you've added, and the situation is they're obvious to anyone. I think otherwise there is the concern that the contracting parties can get confused as to exactly what is the basis that they're organised. The other aspect about life is that these standard contracts are in the form that's been standard in Australia for many, many decades, and they don't really recognise the shift that's happening in construction. If you went back to 1920 and you went to a builder then, he had all the trades that he needed to build a building. He had a concreter, he had a bricklayer, he had everything. He had the electrician who was probably employed by him, and he probably employed a couple of plumbers. So the situation is he had all the technical knowledge in-house, and he was pretty experienced himself in all aspects of building. But with the advance of technology, and that is simply increasing, the reality is that a lot of the actual heavy lifting from a technology point of view is done by the subcontractor. And effectively, we're shifting more and more to a design and contract subcontract in many areas of technicality. The technical things are so demanding that a general builder isn't on top of them, as is a specialist subcontractor who's engaged in that design and installation on a daily basis. So you've got to be careful when you're looking at the standard contracts to say, well, what's the basis on which I'll be engaging all of the people, all of the components involved. So the situation is that there are some gremlins in the standard contracts. You've got to look out for them and adjust them. The situation is if you have a project that is non-standard, that say, for instance, has several parts, that has design and construct on some aspects but not on others, that has a constrained design and construct, something where you've set the overall envelope, but you do want some design and construct input within that envelope, then you'll have to sort of have some amendments and you'll have to sophisticate up your standard. We talked about amendments being separated from the body, so as everyone knows what's happening, and the responsibility for design and the power to vary are two particular aspects. If we look at the responsibility for design, to a certain extent, there's design in every construction activity. If you're installing a door, then where you put the hinges and where you put the connections and how far it's off the floor is something that's done by the tradesman, but fundamentally it's a bit of a design. Again, if you get a design and construct for a hospital, obviously you'll get a lot of design information from the principal before you design it. So you get the beds, you get the facilities, you'll get the technical aspects, the wards that have to be accommodated in it. You get a lot of design information, design criteria before you go forward. So the responsibility for design has to be carefully specified, and it's always an issue when you come to matters of dispute. The situation is that the boundary between design and who designs one aspect of it and who designs the other, and the responsibility for compatibility across the design envelope is important. So it's important to clarify what you want and make sure that you express clearly exactly the responsibility. There is a tendency in many documents to simply put overwhelming obligations in respect to design on the contractor, but the reality is the effectiveness of those clauses is doubtful, particularly where in reality there was an obvious involvement of the principal in design because he had to check and approve it and he had to influence it in order to get what he wanted. So in summary, use a standard contract without improvement is one option, but the circumstance is that's going to leave you exposed unless you put intelligent amendments on it. You've got to commit to continually improving it. If you use the standard without thinking for the last 10 years, it'll get progressively out of date and out of level of efficiency or productivity. And the situation, of course, is you can leave it to whatever you use and take an adversarial approach and watch your back and fight your way through it. I don't recommend the last, because with a bit of brains, a bit of intelligence, a bit of hard work, you can get a contract that delivers a result that's so much more successful. So just take this sort of case study as to what somebody's doing. Sam's the head contractor, selected for his technical expertise in electrical distribution hardware. So he comes from that background. He subcontracted the building works to Bob on the basis that there'd be a premium curtain wall system to be installed and incorporate specialised cladding to match the adjacent building in colour, texture and window profile. The curtain wall is sourced from a specialist supplier in Shanghai, and the external appearance requirements are the condition of the development approval. So you can see at a fairly sort of basic outline of responsibility why it gets difficult for Sam, the head contractor, to make sure that he's worked through to control and put in monitoring procedures throughout that whole process. Because you've got a builder who's not totally okay with premium curtain wall systems. He's got a specialised cladding that is installed in Australia by someone who thinks he knows what he's doing. And then it's got to be sourced from a specialist supplier in Shanghai. So he might not appreciate the subtleties of AS 4000 or any other contract, and he might not understand the requirements for the cladding to match colour, texture and window profile. So you've got an example of where thought will have to be given to specifying that product carefully and making sure your contract matches it up. And again, if you have a specialist supplier in Shanghai, you'll need to watch whether he's happy with the court system in New South Wales or Queensland. So the situation is that if you had to put a clause in there clarifying the role of the superintendent's representative so they could give instructions but not deal with certification of difficult issues, then you'd have to consider how it would work. And you'd have to think about how it's going to approve when it's translated into Mandarin for the curtain fellow. The other aspect is, in that example, is to what extent should you be able to vary the wall profile? Now, if you look at AS2 4000, it'll propose no real limits on variations. But the reality of this contract is, after you've selected your profile of the wall cladding, there's no real option to start varying it. There's no real option for the principal to say, I'd like the struts on that walling to be an inch wider or a millimetre shorter. Fundamentally, it'll come off a production line and it comes as it comes. So it's important to see that there are limits practically and commercially with what one can specify in the contract. And disputes, you've got to look towards, in any contract, one of the clauses you should look at carefully is disputes. Are they going to be resolved sensibly? Is somebody going to say, look, if I have a problem with you, I'll sit down and belt it out and we'll settle it in a number of steps that leads to a sensible resolution. It's important to see that you're confronted with something being settled fairly quickly. So you do want a situation where a superintendent, if he's reasonably acceptable, or an expert can be appointed to resolve things. They're good procedures to have quick and able to be employed quickly in resolving an issue. Again, you've got mediation, conciliation, and you've got arbitration, and they're all attempts to resolve matters quickly. It's common these days to say we'll have a bit of mediation and then we'll go to litigation. And that's, I think, lacking in creativity and lacking in efficiency, because litigation is a wonderful thing if you have to have it, but not much fun if you don't have to have it. And the other aspect is that the role of arbitration, I think, is very much more suitable. Arbitration is designed to be quicker than law. And while it might cost you similar amounts, at least it's resolved quickly. We have the benefit in much of the areas of Australia of the SOPA Act, which generally resolves a lot of problems very quickly. It doesn't resolve all of them all the time, but it resolves a great number of them regularly and efficiently. And one is because it's done so quickly. It's done in 2 months. It's not binding, but it solves lots of problems. Once you get a decision from adjudication, most people are prepared to use that as a basis for resolving the resolution of the whole claim. So the situation is that if you're restricting yourself to SOPA, it's a very good system. And that means that you've got to design your administration of the contract so that if you've got to go to SOPA, your side of the matter has been laid out clearly in your correspondence around it, and also it's been quantified on a sensible basis so that the adjudicator has something to chew on when he gets the matter. The situation is that when you're talking about disputes, and we touched on why you might be resolving dispute with a foreign country resident, you've got to look at the question of arbitration. It's the only practical situation in international disputes. And you've got the fallback of litigation, but you've got its disadvantages. So the circumstance is you've got to keep your eye out for which way things will crumble, what provisions you've got to have in to resolve things, and can you avoid going to litigation for all but the most serious disputes. The situation is that you ought to look at some of the clauses now and look at them carefully to see what they provide. Now, say clause 35, AS 4300, the situation is they define practical completion. You want to watch the definition of practical completion, because oftentimes the definition of practical completion involves a multitude of documentation and requirements and manuals and everything else under the sun, and that's still qualifying practical completion. The problem with that is that if for some reason one consultant is very slow on giving you his view of how light switches can be turned on or turned off or automatically controlled by his electronics, that's going to have you paying liquidated damages for a long time. So the situation is that you should be looking to have practical completion defined as to what the general distinction is, that is, if it can be used, if it's ready for use, despite there being defects or inadequate work or incomplete work available, that the situation is that that's sufficient. The use of partly completed works is an interesting topic, and you should think of it ahead of the signing the contracts, because it's likely to be more sensibly negotiated and discussed then. And that is, there should be an inclination on the contractor side to allow the principal to have occupation of use where there's no safety issues, environmental issues or other bars, in order that that can be achieved and presents value to the principal and value to the project. But you've got to be careful if the principal's occupying areas where there's still work to be done and there's still responsibility in any of those areas that has to be discharged. So it's an important aspect to look at when you're going through it. The other aspect of clause 35 particularly is the situation of delays and the definition of the causes of delay. So the situation is that any of the following: industrial conditions, inclement weather, any other cause, you can have that definition. Otherwise, you can have more tighter definitions on the causes. You need to quickly look at the causes to estimate whether or not the delay claim is any use. Sometimes delay claims are very restricted, and the only one that has to be effectively excused is a breach by the principal. What that means, though, is that instead of administering a sensible time delay clause by going through the various clauses that will have an effect and evaluating their effect and coming to agreements on them, everything that causes delay has to be characterised as a breach by the principal. It builds an adversarial and sort of makes a debating forum out of a project where everything has to be characterised as a breach because the only reason for a delay claim is a breach by the principal. Additionally, focusing attention on the breach by the principal means that usually there is an aspect where, given the breach by the principal, there is an associated claim for money, which might not be the case if one gave reasonable extensions of time for, say, inclement weather. Somehow that might be characterised as a breach, and the situation is end up with a damages claim. The other aspects with a delay claim is this aspect of whether or not the superintendent has to assess them fairly and has to assess them within a regular time. It's very important when you're looking at these clauses that you watch those basic aspects. One is, has it got to be a professional assessment, or is he just doing what the principal tells him? The next aspect is, when has he got to respond to a delay claim? And if, for instance, you say, well, he hasn't got a response and failure to respond within 28 days does not deem the claim accepted. So basically, he can do it when he likes. You do get some big problems with complex projects. One example I was involved in is where the superintendent was going through and assessing the delay claims, and that's a sensible and a healthy and a wholesome thing, except he was doing it 6 months after practical completion to adjust the liquidated damages. It sort of meant that the whole thing had got out of whack, that the reality of a delay claim is you get a quick decision on whether or not you've got the delay or you haven't, because if you've got the delay, you can adjust your resources effectively. If you haven't got the delay, then you've got to accelerate up something. So that decision's got to be made on the spot in real time. Whereas if your delay claims are being assessed months later and possibly after practical completion, it means that the contract administration has got out of whack. Defects liability is important. I would say of construction litigation generally, if there are serious disputes, particularly from the principal side, defects liability will be present in almost all of them. I'd say sort of 75% will have a substantial defects liability claim. Something will be alleged not to be done the way that was expected. So the circumstance there is you should have a clear and sensible approach for fixing defects. So generally, if you went back a few years, you wouldn't find defect clauses saying much at all, but a well-drawn defects clause these days sets out a process whereby the defects will be fixed. It also protects the contractor, because the contractor should ensure that the contract allows him to affect his defects. And the reason for that is it's not that he likes fixing his defects. It's not that it's going to be while he's still on site, because he might have demobilised as well and be coming back 6 months later to fix a row of windows or a series of involved works. The reason is an economic one. If a new contractor comes in to fix a defect, he has, if he's at all rationally economic, he's got to make sure that when he fixes it, there's no defect in there. He can't take the risk of the previous work being up to scratch. Fundamentally, he's got to cut it back as far as he needs to assure himself that the work that he will add onto it and that work will be kosher. Whereas the existing contractor, he knows the work he's done otherwise has been okay. He knows there's a minor issue to resolve to fix the defect. He can fix that defect quickly with that minor issue because he's responsible for all of the work, and he'll be responsible if the previous work fails. Therefore, he's not accepting any bigger risk in doing a quick and effective rectification work. So the situation is it's important for contractors to ensure that they get the opportunity to fix their own work, they get reasonable times to fix it, and that oftentimes there is a resolution of the method and the implementation of the method in fixing defects. So the contractor should provide that when we fix the defect, I'll present it to the superintendent and he'll get back to me, say, within a week and tell me whether he accepts it or not. It's important that you put a week on it, because if you're mobilising to fix defects, you want to know whether they're going to be fixed, they're going to be accepted or not, in order that you can demobilise. But having mobilised, the superintendent, again, is probably voicing what the principal tells him to do, and he may be pretty unreasonable in respect to the rectification. Well, there you need to provide another clause that in the event that the rectification work isn't accepted, then either party can bring in an independent expert to adjudicate. It's important to get those clauses in there, because then people are bound to comply with them. And otherwise you'll find that the defects are exaggerated and the effect that comes out of them is is pretty enormous. The other aspect is that when a court has to deal with defects, it's a messy situation. The courts struggle as far as they can to reduce the dispute to where it's able to be quickly decided. But if you've got 300 defects and you've got experts that differ with each of them, and each of the experts has to explain exactly why he differs, you've got a very long trial. A long trial causing lots of pain, suffering and cost. So the courts do what they can in terms of getting the experts to inspect and getting the experts to confer, getting the experts to decide, if they can, to agree things. But subject to that, you do have a lot of effort and work going into defects. The other aspect about defects is that they can be trivial, but they'll cause a lot of trouble to determine. So in lots of defects, a scratch on a door, a leak in the pane, a break in the waterproofing of a window, it'll cost you as much to inspect it and report on it as it will to fix it. And you get a wide series of these disputes, wide series of defects, and a very expensive process. So looking at defects clauses, usually when you come to sign the contract, isn't going to be a big problem. It's not going to cause a lot of acrimony as to how people decide it then. But by deciding a sensible and fair system, you can save yourself a lot of angst, a lot of problems. So again, you've got this aspect of the rectification, the scheduling of it, the organisation of it. So the situation is you've got to be careful sort of to do it in a way that's sensible. On the one hand, as you can see in this clause, the situation is that if the work's not commenced, then the superintendent will have to get the rectification carried out at the contractor's expense. And as we've explained, that's going to cost a lot more, cause a lot more delay, and cause a lot more confusion. And then if the defect reoccurs in a couple of years, instead of the contractor coming up and buttering it up, it's going to be a fight between the contractors and a mess to administer. The other side is you've got to schedule it. The situation is that's easier said than done, because if you've done a block of units, the situation is it requires the patience of Job, an enormous effort to get everybody in the units able to let the contractor have access. And he might need access for a short time over 5 days as something is reorganised and it takes time to cure, and then it's got to be painted up. So it's an involved process, and it's a process that should get a good bit of attention. Variations are very important. There's a standard way of dealing with variations, and that's pretty traditional. But it's important that both parties get organised as to how they're going to deal with variations. In particular, whether or not the contract is going to be expected to do a full variation claim for each potential variation without that variation necessarily being accepted. There are contracts which say that all variations that are asked for by the superintendent are provided free, but inevitably that revolves in a deficient scenario of presentation and acrimony over what's offered and what's not. I'd rather have a situation where the specification of the variation should be done by the superintendent. He specifies exactly what he wants. He then gets the quotation from the contractor that defines that he can provide that spec and the price, and you get some agreement before the situation goes too far. Asking the contractor to give very long and detailed estimates and specifications and subcontractor engagements and everything else for the variation often just means that they're delayed. And if a variation or the prospect of variations in the prospect, it delays the other work on the contract and messes up the whole sequencing of work throughout the project. So be careful. The other aspect about variations is on what basis you ask for them. If you ask for a variation on the basis that it'll be fitted in by the existing team, that'll be cheaper and easier, then of course you've got to expect that there'll be an extension of time. An extension of time fundamentally with costs. So the other alternative, which if appreciated early can often solve problems, is to say no, price this on the basis that you'll get extra people, extra resources on to do it. So therefore it should only be the extra management, the extra resources and the job's done, but it'll be paid for at a more expensive than if it was done directly by the people on staff. But it will avoid, in most cases, much of the delay. It's important to clarify things at the time the variations are asked for in order to get the best result. You'll see that there's a good bit further on variation in order that you understand what your contract provides. It's important to walk through that. It's important to see what's a variation, what's not, and the cost associated with it. The scenario is that the situation with variations as well is you've got to realise that the law puts some fairly substantial restrictions on a variation clause. Fundamentally, they will mean that you can't use variation clause to change the nature of the contract. You can't take half the work out. You can't take half the work out and give it to someone else unless you've got the most detailed of clauses that everyone's agreed to that process. So therefore the situation isn't to use carte blanche. You've got to use it with some understanding of the contract. The other aspect is in some variations, rather than get that work done as part of a building contract and try and mesh it in with a building contract, sometimes it's easier to leave it to the end and get that done as a separate contract and possibly with a separate contractor. Then you've got to be worried about clause 46. So the situation is the claims notification, as soon as practical, you've got to notify and you've got to give all the viability and you've got to get a prescribed notice where there's got to be an outline, quantum, etc. It's all an attempt by people to control claims and to see that claims are brought up quickly and hopefully resolved. But it's a warning to the contractor that he's got to have the resources on to do that. And those resources can't be brought in when a problem arises because they come in too late with the time bars that are applicable. Additionally, if they come in too late, they often come in unprepared. They haven't got the contract there. They haven't followed the forms. They haven't got the information available conveniently for the claim. All of that should be priced at the start. If you've got a contract as a contractor and you know the types of claims that are inevitably going to be made in this contract if it goes other than expected, they should be practically prepared before you start. And you should be checklisting your progress through the works, checking for claims that need to be made, checking for variations that need to be made. And then you've got to have the diplomacy to make the claims in an unaggressive, unadversarial way. You've got to be able to say, look, I've got to claim 7 days for the delay that's occurred because the concrete pour was cancelled by you, but I'm working to see if I can make that up as far as I can, and I'll give you a report at the end of each week. So the situation is there's some commitment to the ultimate purpose of the contract and the ultimate purpose of delivering the work at a sensible value, rather than taking advantage of every bad luck that's happened to strike the principal as you've been through it. So 46 in the AS 4000 is a warning, and it'll be reflected in most other standard contracts, and you've got to be careful that you observe it completely. The situation is as well with looking at time extensions again. You've got to look at what are neutral clauses, that is, weather is somewhat neutral. Change in regulation is somewhat neutral. The situation of involvement of perhaps of neighbours gets close to be neutral. And then you have contract clauses. So the situation you have the contractors out of sequence work, a contractor hits a rock that isn't his problem, and alternatively a contractor has machinery breakdown, or he has staff problems, or he loses his sequence of work, one or two of his subcontractors don't perform on time, and he's got some problems. So it's important when you're discussing them that the neutral clauses are much more likely to get you at least time, not usually money, if the weather is inclement. That's usual to provide. But of course, the contractor clause is much more likely to get a rejection. The situation is detail the permissible clauses, identify them very quickly when you look at a contract because they will set the tone of it. You should have an idea before you start of the time or cost impacts of delay. You should say, right, what happens if I'm delayed on site? Well, how many men have I got? What's the story with them? How much equipment? How much there? So you've got provisional costs discussed and itemised. And sometimes it may be in the interest of the principal to pay delay costs and pay for a week's delay cost in order that he can get other work done in a proper sequence or otherwise amend the contract in a better way. The situation is that, again, you've got to look at all sorts of delay claims and say, for instance, the principal nominates a nominated subby, so he wants his electrical works to be done by his favourite cousin. So he nominates the favourite cousin in the contract and the contractor says, yes, all right, well, I'll use him. What's happening if that contractor doesn't perform? Or alternatively, if he goes broke, or alternatively, he gets the best job known to man down the road and this job is under-resourced. You want to work those things through carefully where there's a choice made by the principal. The other aspect is where the principal himself sometimes offers to do things. So he says to a constructor, well, look, you can build the building, but I'll do all the earthworks because he's an earthwork fellow himself or he has a cousin that does it. You really got to realise that there's warning bells and flags go up at that time, because if you have your principal as a subcontractor, you've almost certainly got a mess on your hands and a dispute in the offing. Neutral clauses we've discussed though, in the circumstances you should look to do them. You've got to be careful with neutral clauses because, say for instance, there's a situation where we have a supply chain problem. That is not the usual one where your subby won't get out of bed, but on the one where the Chinese factory doesn't bother to send you something for a couple of months because they're going to send it to someone else. Or the Donald produces a big fat tariff on somebody and therefore he's got some problems in supply. So those sorts of clauses now working their way into contracts because the COVID was such a big risk and it sent a lot of contractors to the wall or to a very close association with the wall during the period and also in the flow-on effects in the year after, because people couldn't get subbies, people couldn't get supplies, people couldn't get lots of other things, and they couldn't get them at the speed and at the certainty that they previously programmed. The other aspect, you'll come back if you ever get a chance to, have a beer with somebody that wants an argument. You can argue about the float ownership. That is, who owns the float? Who controls the program? If there's a non-critical activity, who's entitled to use that for their benefit? Does the contractor own it? Does the principal own it? Usually, if it's not stated, you're probably likely to have the contractor owning it. That is, he's promised his building to be finished by Christmas, and the situation is he should be able to have the flexibility to flex his resources and tasks in order to do that at the minimum cost. But it's important not to have a fight over it during the running of the project, because it's an important aspect. And it's an important aspect because even the critical path can be adjusted from time to time. Extra resources can be put onto it and then because it doesn't become critical. Or alternatively, the non-critical paths can be delayed until they're critical. Flexibility of managing that is a topic of concern. The real aspect is who controls the program. Is it important for the principal, and is he prepared to pay for the privilege to manage the critical path carefully and insist the contractor work on the critical path item by item? That's an aspect that needs to be debated. But you don't want a situation where the contract's signed on the usual principles, that the contractor owns a program and its float, and then have the owner want to debate that continually through the running of the project, through the assessment of the delay claims, and through the management of the program generally. Most standard contracts will have the superintendent having some role in being able to adjust the program and requiring the contractor to bill to it. But that's different from an active management situation, which has the contractor unable to manage his resources properly. And of course, it's possible, but it'll usually come with a big cost increase. Variations in EOTs, we've covered them in the running through carefully, but the situation is that you've got to be careful when you order a variation. Does it involve an EOT or not an EOT, and what's the cost consequence of that? And the realisation that that'll often require a delay issue, a compatibility issue. If you change some of your security cameras halfway through, you'll have a problem. So you've got to look at the variations and put as much effort into their design and their planning and their management as you did the original tender process that you put forward. What actually matters, well, the situation is contract selection is only the starting point. You've got to do the amendments and you've got to fashion it to your particular project and your particular bundle of risks that you're prepared to take. Administration behaviour, if you set the culture on site that everyone's clean and tidy and puts their variation claims in on time, then that's a certain contract culture. If you have a culture that nobody worries about the administration except everyone fights at the end of every progress claim, that's another culture. Is not to be recommended. And the early strategy prevents the downstream disputes. If you can get on top of things early, if you resolve things early, they inevitably mean less harm to everybody. So the AS 4000 2025 doesn't remove the risk, it redistributes it. And the situation is that successful projects are built on a disciplined contract strategy and a lot of hard work by a lot of people. But the situation is, they say that hard work spent on contracts is enjoyable, rewarding, and makes a better person of you. That's the material I wanted to cover today, to actually attract you to the contract and see the flexibility inherently in contracting, and also the importance that each contract provides to the overall success of what is a complex and challenging mission. And I'm pleased to have had the time with everybody, and I'm pleased to make sure that everybody now is more attracted to contracts and more confident to put a positive contribution to them. It's far better to write a clause in it at the end of time when you're just about to sign it to say, well, I've got to have access from the back road, or I've got to have this, or I've got to have that, than not to do it. If people put down their important points, their last minute suggestions, they're better off to run the contract thereafter. So I encourage you all to do it, and encourage you all to take an interest in contracts and make sure that they're serving the purpose that they should. thanks very much for that and all the best.